Hello, we're live. Give me 1 second just to refresh my YouTube and get that muted so we're not echoing all over the place. Hi, everyone. How are you all doing tonight? We got a lot to talk about. All right, there we go. Hi, Jess. How are you?
I'm good. How are you?
I'm
Long
good.
time no see.
I know I haven't seen you in 20 minutes.
12 hours. Yeah.
Let's see who's in chat. Hello, everybody. Rosie, I'm glad to see you. I was worried about you today because I haven't heard from you yet. So, hi, Rosie, Feeding It, Mimi, Nola, Sam Costa, good to see you. Robin Swan, Sugarbutt Williams, how are you doing, hun? I'm glad to see all of you here in chat. Sorry for all the names that I missed, but chat scrolled back quite a ways. So, Jess, we got some new stuff to talk about today.
Absolutely.
Oh, goodness. There's a bunch, not a bunch, there's 3 new filings in the case. So I figured the easiest way to do it is to go live. We're going to read through all the documents and we're going to talk about what they mean because they don't mean what it appears on the surface, as is usually the case with legal filings. So we're going to get into it. I'm going to put the first one right up on the screen now. This one was filed the other day. This is by Rob Wood. And this is one of his responses to the ongoing discovery issues. Why don't I have this here? Window. There we go. I got this. I understand how to internet. Yep. Okay. What you see on your screen, this is the first filing that we're going to talk about tonight. Let me read through it quick and then we'll talk about it. It says, comes now by the state of Idaho by and through the Madison County Prosecuting Attorney's Office and pursuant to Idaho Criminal Rule 16, hereby notifies the defendant of the following. Number 4, documents and tangible objects. A, defense counsel can inspect and copy or photograph the items or material described in Idaho Criminal Rule 16b4 by simply making prior arrangements with the Madison County Prosecutor's Office or the law enforcement agency holding such items as evidence. And B, in addition to the above, the state may also utilize the following as evidence at the trial, all of which has either previously been provided or is attached hereto. Please see Addendum E. Now, we don't get the addendum in the filing, unfortunately, so we'll have to guess what that is. But this is Rob Wood saying, hey, there's some evidence. Obviously, I can't give it to you because maybe it's a single item that can't just be, it's not a file. So he's saying, hey, all you have to do is come tell us what you want to see and make an appointment with us or law enforcement, and you can have access to it. So that seems pretty standard to me. Not a big surprise. What do you think, Jess?
Yep, normal.
Very normal. Right. So remember, they have been going back and forth on discovery for a very long time now. And they just keep going back and forth with the same things. The defense says, hey, we need this. Rob Wood says, hey, here you go. You can have it. The defense says, Rob Wood said we could have it, but he didn't give it to us. Rob Wood says, well, I said you can have it, but it's right here. And it's like, guys, put everything on a table and have at it. This is starting to drive me nuts. So that was the first thing. Now we come into this. This is a different ball game. All right. It's still a discovery issue, but it's very specific. All right. I'm going to read through it and then we'll explain what it means. All right. Okay. So this is from John Pryor. So, whatever. All right. Comes now John Pryor, counsel for the defendant, and hereby respectfully requests the court set an expedited hearing for defendant Chad Guy Daybell's motion to oppose use and motion to preserve DNA samples. Motion for photographic recording of all serology. Oh, oops. Sorry. I'm having window issues here. I'm trying to move it so I can read it. It's not working so well. All right. I will just have to lean to the side. Chad Guy Daybell's motion to oppose use and motion to preserve DNA samples. Motion for photographic recording of all serology samples and other visual tests. Motion to review all lab records, processing procedures, policy procedures, and reports of the state lab or other lab performing testing on the samples relating to this case. That on April 21st, 2021, the special prosecutor, Rob Wood, sent correspondence to defense counsel that he intends to perform DNA testing on samples obtained by law enforcement. On April 21, 2021, he submitted to my office notice that there is additional discovery not yet provided to defense counsel that will be forthcoming. This additional discovery included, but was not limited to, some DNA testing that had not yet been provided to the defense. That he notified my office by such correspondence, and that additional DNA testing would completely consume the remaining DNA evidence obtained by law enforcement. Pay attention to that line. That's the most important line. This would preclude the defense team from seeking independent testing by their own expert. The defendant is requesting the following: that the court order the state not to pursue any testing on remaining DNA samples until such time as the defense can obtain half of all samples to allow defense to perform their own DNA testing of all samples. That the court order the state to provide all records, reports, documentation related to the testing that has been performed to date. That the court order the state to allow defendant's DNA expert to go directly to any lab testing such samples to review, copy, photograph, and document any and all processes, tests, procedures, testing procedures that will be performed on the additional samples and have been performed to date. Provide to the defense any and all other evidence relating to DNA testing in this case. That the court order the testing agency performing any test to photograph, record, and document any serology, microscopy, or any other visual test performed or to be performed on any DNA sample related to this case. That the state be ordered to allow the defendant's DNA expert to examine all qualification evidence, extraction evidence used and documented by the state's lab. That the court set an expedited hearing on this matter to avoid the state moving on its intention to consume all DNA evidence prior to defense having the opportunity to even review such evidence. Okay, that's kind of a big deal. What do you think about that, Jess?
That is a big deal, but we've seen it before. It's nothing new.
Yep, there are many.
Not seen in this case, but yeah.
Yeah, we've seen many cases where there's a very limited amount of DNA available. All right, and if the state does certain testing will consume the actual sample, right? And if there's not a big enough sample, one test could consume the entire sample, and then that's it. You've got nothing left to test, right? We've seen this in the Crystal Kenny. We saw it with Crystal Kenny. We saw it in a couple other cases I can't remember offhand. Usually what will happen is both sides will stipulate to a testing procedure, and both sides can be there at the testing facility. They can observe the process. They can both have immediate access to the results. It's not like just the state gets it and the defense has to ask. So that's the only sample. Both sides have a right to it. You know, they really do. So, you know, that's the thing. Jess, your message got deleted by the Google moderator team. That happened to me last night in Paul's live. I guess we can't link to Teespring anymore in the chat. So,
well, that one was Amazon, but okay.
Yeah. Well, there you go. I guess it doesn't want us.
People where we got our antlers. I'll put it under Discord if you guys really want it.
Yeah, and we can add a link in the description too afterwards. So, all right. So that's what John Pryor is saying basically is, whoa. We need an emergency hearing because the state is about to use up all of the DNA sampling and we won't be able to do any tests on it. That's really not fair. And I agree with him. That is absolutely unfair. That's not how it's supposed to work. Both sides should have access to it. So we'll get to the hearing in a few minutes, but this is John Pryor's argument. This is not a frivolous argument. This is kind of a big deal. And I agree with him. Do you agree, Jess, or do you think he's just, yeah?
Well, you don't want to get a trial thrown out because the other team didn't get to, use the DNA or whatever it is that they have.
Mm-hmm. Yeah, Miss Wee Lassie has a good question. Said, if Rob Wood had already told John Pryor that there's insufficient sample to share, then how the hell is Pryor asking for half of it if there's only enough for one test? John Pryor at this point doesn't know if there's only enough for one test. I just gave that as an example of this. Rob Wood has said that the DNA samples will be consumed in the testing process. There could be 4 samples, and they're doing 4 tests. So basically, Pryor's saying, listen, either you're going to give us half of this DNA so we can test it ourselves, or we are going to take part in the testing process right along with you, and you can't hide anything from us, which is absolutely fair. So that's what's going on there. Now, the next one. All right, Mark Means
case had this going on too. The one from the podcast, I can't ever think of the name of the podcast. Where the girl was murdered and they're trying to get, what is Saeed? Is that his name?
Adnan Saeed, yeah.
Yep. They used this. This was a big part of that trial.
Yeah.
Yep.
All right, now the next set of documents. These are from Mark Means, so these are going to be fun time. Oh, let me get these back up on the screen. All right, Mark Means.
Your friend.
Mark decided he wanted to get in on this too, right? And again, not without cause. He has reason to pay attention to this. He filed a declaration, a motion to oppose use of the DNA, a motion to preserve, motion for photographic and sampling, whatever, all this stuff in one motion here. So let's read through it, and then we'll talk about this because this gets into a whole different issue. Okay. Comes now defendant Lori Noreen Daybell by and through her attorney Mark L. Means of Means Law Office, PLLC, and moves this court as follows. Defendant hereby joins the motion filed by defendant Mr. Chad Daybell by his attorney John Pryor. So right there he's saying, all right, I'm in this with John. We're doing this together. But going on, that attached is a true and correct copy of midnight correspondence to counsel from the prosecutor in this matter, as well as true and correct copy of the email sent from prosecutor Wood, which was CC'd to the court directly. Counsel has previously requested that this prosecutor cease all CC information with the court, that is improper in a form of ex parte communication and the like. This continual improper communication places this court in an awkward situation unnecessarily by said prosecutor. It appears the prosecutor is attempting a backdoor communications method to potentially protect himself from a Brady violation finding of this court based on the prosecutor's continual refusal to provide full and complete discovery responses. These direct improper ex parte communications are potentially making this court unnecessary witness in future litigation. Defendant Lori Daybell hereby requests, as set out by Mr. Pryor, all relief sought in this motion and an order of this court of instruction to counsel to cease this unnecessary ex parte communication. All right, let's stop there before we go on. Yeah. Okay. First of all, if this were a true ex parte communication from the prosecutor to one of the defense counsels, he's got a point. Okay, I did some research on ex parte communications, and I'll put that up on the screen. There are certain circumstances where you can do that. There are certain circumstances where the judge can allow it, and there are certain circumstances where you cannot allow things of this nature. All right, so he's bringing up a valid legal argument, although I'm not convinced that this is that situation, because as we're going to see in a minute, Rob Wood's letter, the correspondence that he sent to John Pryor, is CC'd to the court and to Mark Means. How does that can make it ex parte? This is a legal question that I'm looking into, because the notification went to all the parties involved, including the judge. Whether it's an ex parte communication or not is a little bit up for debate, I think. That's my personal opinion. So we're going to get into that in a minute. But Jess, what do you think of this part of the filing? Being as nice as you can.
If he doesn't like people to think that he's incompetent or in over his head, this kind of squabble BS can go on. I mean, this is ridiculous, I think. If he got CC'd, if the court was notified, what are we arguing about?
Right. That's
about
point.
Something that's relevant. I mean, really, come on.
Yep.
They're not sending text messages behind your back, Mark Means. Like, nobody's not invited you to the sleepover this afternoon. Like, you're fine. Grow up.
I need to interrupt for a second and say, Rosie, thank you for this super chat. Look, she got hedgehogs too and koalas and flowers. Thank you, Rosie. You know how much I love you. I appreciate you so much. Thank you. That was great to see. Okay, so I do agree. I'm not entirely convinced that this is a true ex parte communication. However, depending on your interpretation of ex parte outside the presence of, okay, is he arguing that this should have been done through the court? Yes, and it probably should have been. Is that going to hold water? We'll see. But certainly, I know a lot of people like to have a go at Mark Means, but what he's really saying here is, hey, let's file all these communications through the court so we have a proper record. Right? There's nothing wrong with that. There's nothing wrong with requesting that. And Rob Wood has repeatedly violated that request. So, okay, let's ask the judge. Let's ask the judge to fix it. That's not entirely unreasonable. Not entirely sure he has a legal standing for that because they were all notified, but we'll see. So I'll do some more look into the ex parte section. Ex parte just means outside the presence of or without a particular party. So that's what that means. All right, let's go on to the rest of this filing here because we'll understand it a little bit more. Share the screen. Back to the photos. Here we go. All right, next, attached to this filing, we have the certificate of service. That's no big deal. All right. This is the letter that Rob Wood sent to John Pryor. Okay. This is the letter that they're all upset about, as claiming that this is an ex parte communication. So let me read it and then we'll talk about it. This was sent from Wood to John Pryor. He says, Mr. Pryor, I'm including Judge Boyce and Mr. Means on this correspondence because I'm following up on a matter that you brought up during our recent status conference on April 7th, 2021. You mentioned at the conference that you estimate that you are missing 30 items in discovery from the state. To date, I have not received any specific information from you regarding what you are missing in the discovery from the state. You did send 2 letters regarding discovery in the recent months, and we responded to those requests before our recent status conference. I would note that all the items requested in those letters had already been provided to you or have since been provided to you by other than Tammy Daybell's autopsy report, which the Fremont County prosecutor, Lindsay, has not and will not provide to my office. You did mention at the hearing that you have not had the opportunity to review everything that we sent to you. Needless to say, we were surprised by your statement in court that you are missing such a large number of items. According to our records, we believe we have provided you with every document in our possession, and you are entitled to under the law. My paralegal is prepping a small supplemental disclosure of items we have just recently received, and it will be sent to you and Mr. Means no later than next week. However, if you believe otherwise, please provide me with a list of specific information that you are missing and legally entitled to in this case, and I can address your concerns. Regards, Rob Wood. So, what do you think of that?
What are they doing? I mean, this seems like such a little sandbox argument,
Yes.
We keep fighting over it. I'm just sick of hearing about it. Give him what he's entitled to. I don't want to see any more hearings on. He has something. I know he has something, and he won't give it to me. It's like a 3-year-old. He's touching me like all over again, over and over and over.
Mm-hmm.
Give it to him, whatever it is. Just give it to him.
Yep.
But at the same time, this crap about Tammy's autopsy, what's that got to do with it? Destroying and hiding evidence over 2 dead kids.
Right.
Does he have a guilty conscience? Like, what do we want Tammy's autopsy for?
Mm-hmm. Yeah. Now, Sam Costa said that's how proper communication is handled. Yes, it is, Sam. I do agree. Rob's letter is certainly very clear, very to the point. But he probably should have filed it with the court instead as a response on the record, as opposed to a letter like this. So, whatever. But the bottom line that I see, trying to come at this very objectively and very non-emotionally, is that they're just fighting over stuff that's going to have to come out anyway. Anything that Rob Wood wants to use in court, he has to give the defense anyway. Why are we holding this up? Just give it to them. Okay, now Rob Wood may be trying to hold some things back that are part of the ongoing investigations. He may not be ready to disclose certain things. I get that, but there are limits and time limits on these things for a reason. So it's about time they all just got in a room, put all the evidence on the table, and have a go at it, because this is getting ridiculous on both sides. Okay, I'm not arguing pro defense or pro state. At this point, I think they're all being toddlers, and I want them to sit down and get this done so this case can move forward. Rob Wood, if you've got stuff, give it to the defense. Stop playing around, because all this, well, I sent you something, but you didn't say what you wanted, but haha, then I file it with the court saying, well, you can't have those things. Well, I want these things. Just stop, all of you. I really want to smack them all around. Like, quit it.
It would be different if the court was open and this was a normal time. But every time that you have to go have a hearing on Zoom, scheduled between all 50 parties, whatever, when this could have been done with. I mean, I want something that you've got. You're supposed to give it to me, but you have to guess and figure out what it is. Like, don't waste any more time. Just tell him what you want. My goodness.
Now, a lot of people in chat are saying, but I thought Rob Wood did give everything to the defense. No, he did not. There was one of his other recent filings where he went to the judge and said, you know what? I don't want to give him this, 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 and this. I don't want to turn that over. So he's not giving everything to the defense, right? Don't put Rob Wood on a pedestal just because he's the prosecutor. Okay, the same reason don't throw Pryor and Means into hell just because they're the defense attorneys. They're all making mistakes on both sides. And this is getting to the point where I am getting frustrated with it. Okay, and I can be super patient, but Rob Wood has not turned over everything to defense. He's even said so in his own filings. He just doesn't want to, right? He's trying to argue that, well, I don't have to turn that over, and maybe I don't have to turn that over, and maybe I don't want to turn that over. And it's like, you're going to have to at some point anyway, right? The defense has every right to every piece of evidence that Rob Wood is going to use in court, and he has to provide that to the defense before the trial. That's the law. So let's get on it.
It's almost like this Perry Mason kind of argument, like they're trying to hold something back. So at the last minute in the trial, they flop open a briefcase and there's a gun and this is the murder weapon. Like that is not real life, They have to have discovery. Discovery has to be turned over so that it can be tested and refuted and all that stuff. You can't just pull stuff out of nowhere halfway through a trial. Just give it to him.
Yep. Miss Lassie says, bring in Miss Smith. It needs a woman to mix all and bang all their heads together. I agree. Totally agree. Mary Rose has a really good comment. She says, none of them want a trial. I think Wood keeps hoping they will plea. I agree with you. That could be what's going on here. Let's just, get them to the point where they're ready to crack and plea and start talking. That could definitely be it. And Parmdari mentions that Mark Means was on court TV. Yeah, but before we get to that, let's get to the last page of this filing. There's one more page.
He should have wore his antlers.
Yep. All right, now this is a letter that that Mark Means sent to Rob Wood. And my first question is, if it's not okay for Rob Wood to have ex parte communications, why are you doing it? But
good for the goose is good for the gander.
Maybe we'll figure that out. But this is what he says. Dear Mr. Wood, I joint in Mr. Pryor's objection regarding consuming all remaining DNA samples testing. If you proceed, I will seek, as Mr. Pryor stated, all remedies available for my client for this unprecedented attempt to unconstitutionally handicap the defense in this case by your suggested actions. As formal notice, I am requesting, as if discovery requests were not sufficient, that all reports, records, information, notes, etc. be provided immediately regarding this matter and any other matter or issue in regard to this case. Your office continually appears to have intentionally and wrongfully withheld this discoverable information and documents to date for an unreasonable amount of time. Please confirm through writing that you will comply with these requests today. Email would be appropriate, or I will seek injunctive relief as well as other remedial measures readily available. Regards, Mark L. Means. Okay, now...
So he can decide that he can get an email? Like, Means gets to decide what's ex parte and what's not? Okay.
Right. That's a problem. That's a problem that I don't understand how he's coming at it that way, because if Rob Wood can't send an ex parte letter, neither can you. So you should quit it. But aside from that, there is a point to what he's saying. And the point is a little bit buried in the rhetorical nature of this. Rob Wood has evidence. He needs to turn it over to the defense. Let's get it done. And no, Rob Wood should not be able to consume all of the DNA samples that are remaining without the involvement of the defense experts. So I agree with what Pryor and Means are saying. I really do. I don't like the way it was said. I don't really get on board with the whole ex parte communication, backdoor stuff like that. Yeah, I don't know what I think about that, but we got to solve this discovery issue. We really do. This has been going on for a long time. So somebody asks, how is it unconstitutional if he has informed them of using the DNA evidence before it's being used? Kat, because the defense has the right to test it themselves too, right? The defense has every right and a constitutional right to equal access to this evidence. And Rob Wood cannot, on his own volition, just go and burn up all the DNA samples and leave nothing for the defense to test. That's a big problem. We've seen that in a lot of cases on both sides. So
it's usually an argument over who's doing the testing, not even what's being tested or whatever. If there's not a very big sample, maybe they don't want the FBI crime lab to do it because the defense would say they're biased or whatever. They'll want an independent person to do it, or they'll each want the same test done by two different people. That's usually what they're fighting about.
Yep. And Tara Well says, what evidence has he not turned over? I didn't know he was withholding evidence. He is, by his own accord, in his own statements. One of the recent responses that Rob Wood filed in response to another discovery request was to say, I don't want to give that to the defense. He cited a bunch. Now, they don't cite the exact items. We don't know what particular pieces they're looking for. All we know is there evidence the defense has asked for, and Rob Wood has said, nah, I don't really want to turn that over, and the judge has to make that determination. So, yeah, it's been going.
It's like King Solomon and the baby. He's going to tell him to cut it in half, and one of them's going to have to give up,
Yep.
That's what it feels like.
Right. Tracy asks, what DNA? Well, I have an idea about that. I do not know this as a fact. This is my own theory, but they would not be worried about a little bit of DNA samples from the children, from JJ and Tylee, because they can get more DNA from the children if needed. I would expect that this is some sort of forensic DNA, something on, say, the garbage bags or the bucket or something in the crime scene that they were able to get maybe epithelial cells off a surface, but there's only a tiny amount, and testing it will destroy that sample. So that's what I think.
Hair caught in some duct tape, something.
Yeah, so that's what I think this DNA evidence is. We might hear about it at the hearing. Oh, the hearing. I forgot to show you the hearing. The judge did respond to this today and has scheduled a hearing. So let me put that on the screen. All right, this hearing is scheduled for the 28th at 9 a.m. in front of Stephen Boyce. It will be via Zoom. I will bring it to you live, assuming it's public. Will it be public? I don't know. Depends on the nature of the evidence. They could not want it released, so they could do it in a breakout room. But we're going to see. We always come here and hope for the best. Sometimes we can see it, sometimes we can't. But 9 a.m. Mountain Time, which is 10 a.m. Central, 11 a.m. Eastern, on the 28th. So right here, just a couple days, and we're going to see what happens. They are going to argue this exact thing in court. They're going to talk about the DNA evidence, how they can use what evidence they have, so both sides have free access to it, things like that. So we will see that on Wednesday. Is that Wednesday? 28th. Yep. Next Wednesday. Tracy says, I was wondering, because I thought it might be from Tammy's autopsy. Yeah, nothing like this. These Pryor and Wood would not be arguing about evidence in Tammy's autopsy, because that's not part of this case at this time. It may become, it may be a separate case. But right now, Wood and Pryor have, or not Wood and Pryor, Means and Pryor have no right to access Tammy's autopsy findings. So, Sam, I wouldn't think it's from Tammy or Alex or Joe or Charles or anyone else other than the children, because the only people involved in the current charges would be JJ and Tylee. So what do you think of all this mess, Jess? Are you as frustrated as I am, or do you think this is par for the course with big case like this?
They're going to argue about it sometime, I guess, but it's getting old. I'd rather, where are the charges? That's what I want to be arguing about. Give us another something good, give us something. Don't keep fighting over something that's already there. Sorry. Do you think there's anything in that the letter was sent to Pryor and Means was CC'd?
Not really. Not really. It seems like he's just saying, hey, you said that there were 30 pieces. I don't know what you're talking about. Be more specific. Let me know and I'll get it to you. But we've seen in the past that Rob Wood has said, okay, I'll turn over the discovery, and hasn't. So is that just another, stringing things along moment? Is he serious? We don't know. Should that have been filed with the court? Yeah, I would say it should have been. Yeah. So let's take some questions from chat. Guys, if you have questions about the case, now's the time to start asking them. So let's look in chat. First, we have one from Tara Wells. Since Tammy was in Fremont County, would Rob Wood be involved in her case? Yes, he would be. Rob Wood was named the special prosecutor of Fremont County, meaning that he has prosecutorial powers and investigative powers for anything that arises as a result of the investigation with JJ and Tammy. So yes, he could be, or Fremont County could do it themselves. It's up to them and Rob, but he could have jurisdiction over Tammy's case. So Jess, you ready for a question? Let's find a question for Jess. Okay. Next one from Carolyn Maslin. Where's Melanie Pulowski? That's a good one.
With her baby and her husband.
Yes, she is. I forget what state they're in. I know I have it somewhere, but she is still married with Ian. They just had a baby, and she's living her life. So, does
Well,
she
she
need to be
can.
investigated? Yeah, for sure. Um, Cynthia Berg says, "Is it odd that they're still doing testing?" This is a point that Mark Means does raise. He's like, "Why is he bringing this now, saying, 'Oh, I'm going to destroy all the DNA evidence because we're doing testing now,' when he's had it for a while? He certainly had some things since like October or before then. Why is he just doing it now? What do you think, Jess?"
Two things. Could be because Rachel Smith is on the case now, and maybe she's like, all right, let's get this going. Or she's noticed something, found something, investigated something, whatever. And there's something to test now. Or since the court system is so dang backed up for 2020, whoever is supposed to be testing this could have been so far backed up. I would hate to see an FBI crime lab this year,
Yeah.
just the sheer amount of cases, and they aren't going anywhere. So all that crap is stuck in an evidence room that's just waiting to be done. And I'd say there's a lot to be tested in this case, not necessarily that would be used up, but I mean, you got
Hmm.
two bodies, potentially more. There's no telling. I just think that maybe the sheer amount of stuff could be way backed up from being tested. It could be innocent, completely out of Rob Wood's hands.
Yeah. And let's remember that even the prosecutor's office, even Rob Wood's office, I think 4 people work there. This is a really small town. It's a small area. The counties are tiny. They don't have big teams of experts like you usually see in the big cases when we watch them on court TV and everything. This is a very tiny operation, and Rob Wood might be buried. He might be snowed under. Now, with Rachel Smith on the scene, maybe she's starting to get things to bring some organization to it all. Being like, hey, you never tested this. We got to do that right away. Who knows how far back she has to, back up 10 and punt and start with her prosecution of the case. So
Yeah.
that could be. All right, the next question. Do you think David Warwick has possibly given info to the prosecution? What do you think, Jess?
Um, Probably not. I don't think they're giving anything to anybody. I'd say if he's not in trouble yet, he doesn't have a reason to give anything to anybody.
Mm-hmm.
Not get
Yep.
involved would be the name of the game on that one. Works for some people, apparently.
Yep. I would say if either side was interested in talking to David Warwick, now would be a good time. We know that he and Melanie Gibb have recently separated and gone their separate ways. I don't know if they're going to follow through with divorce or it's just a little breakup or who knows. But now might be a good time to bring him in for some questions. He may be feeling like talking. So, yeah, I would strongly suggest that. Oh.
Maybe wearing black to your wedding isn't a good idea, Melanie.
Yeah. All right, Judy McGuire asks, does anyone think that Mark Means thinks that Lori is innocent? I know it doesn't
No,
matter.
I don't think so.
Yeah.
I bet you he hasn't asked her. If I was a defense attorney, I would not ask if I didn't want to know.
Plausible
Because
deniability.
you can't argue that in court, right? I mean, I'm not a
Right.
lawyer, but you can't go in and specifically say anything that you know to be false. So if he
Mhm.
just flat out asks her, "Did you kill your kids?" and
Yep.
she says yes, he can't go to court and try to argue that she didn't. So
Mhm.
if he's smart, he didn't ask her, and I'd say she would
Definitely.
have batted her eyelashes, and he would have forgot his own dang name at this point. Done.
Yep. All right, moving on. Jenny Blake asks, the police should be pretty embarrassed with no murder charges after all these deaths. And I will say absolutely not. It hasn't even been one solid year since they have discovered the children's remains. If you follow true crime, you know prosecutions like this and even bringing murder charges can take years, many years. So I think that they've moved rather speedily as far as these things go. They're in jail. They've been there. Lori since February or January. Chad
Mhm.
since June. They've been incarcerated the whole time, so they are held safely in jail, and the state is working on it. So the
They don't
fact that we
have to. Yeah, they don't have to.
right, they don't have to rush. They don't have to rush. They've got them in there on charges that could keep them in there for 5 to 10 years. That gives the state plenty of time to work on the murder charges. So, but yeah, in general, murder charges do not come swiftly unless there is something absolutely clear and obvious. So Yeah.
Somebody brought a case to my attention last night. I think it's Roman Lopez. I don't remember what. It's California, and you would think it's a terrible child abuse story. A dead little boy. They found him in his parents' basement in a tote, like a Rubbermaid tote, and they charged him with torture and poisoning. But they didn't bring murder charges. And both parents have now pled. It's a stepmom and a dad, but they have pled guilty. But they didn't charge them with murder at all. They said they didn't know that they could prove it, but
Yeah.
they took a plea deal. But torture charges, I guess, carry the same weight as first-degree murder in California. So,
Goodness.
I thought, wow.
Yeah. Kat Stallsworth, says, I thought the judge had ruled on the discovery already and basically told Rob Wood to just turn over what he had. Do we know that he still hasn't, especially since P&M keep asking for TD's autopsy? First of all, Pryor and Means have not formally asked for Tammy's autopsy, not formally in a court hearing, I don't think. But we do know for sure that Rob Wood has not turned over, because shortly after that judge's ruling, the last one, where he broke it down. He said, yes, you can have these items. No, you do not have to turn over those items. Okay, Rob Wood then filed that he didn't want to turn over the items that the judge told him he had to turn over. So, yeah, he has definitely not complied with that court order. And, of course, Mark Means replied to that saying, hey, judge, you said we could have this. You still haven't turned it over. So that is an ongoing battle.
Mom, he's touching me. Yeah, we've had that argument.
Yep. All right, let's see who's next. Sorry, my chat keeps moving, so I got to scroll and see where we left off. Let's see. Maybe we can go there and volunteer with sorting and researching. Yeah. All right. Have you guys talked about the DNA request issue? Yeah, we just did that whole thing. So you have to watch it on the replay. It was a whole. We jumped right into that as soon as we started. Let's see. I'm just reading chat. I'm sorry. I know it's quiet. What makes you come to the conclusion that Rob Wood hasn't provided all discovery? Rob Wood's own filings with the court, where he says, I don't want to turn over these pieces of discovery.
Yeah.
That's not coming from me. That's coming from Rob Wood himself. So there you go. Melanie Gibb got rid of another husband. Jeepers creepers. Easy come, easy go with these women who talk to spirits in their closets.
As much as God tells them to move all over these states, they need to start asking who they're supposed to marry, because they sure ain't picking very well on their own. Just saying.
Okie dokie asks, how does the right to a speedy trial play into the current charges? It does not, because both parties waived their right to a speedy trial back at their arraignments. So it's not part of this.
Isn't it 90 days? You got 90 days unless you waive it?
Yep, something like that. So yeah, they waived that. T. Cole says, Mark Meanston needs to do his job. He needs to hire his own investigators. Yes, I see what you're saying, but he does have the right to the discovery. He absolutely does. That's how the law works. In any case, any criminal case that you're going to come up against, the information and evidence that the prosecution has to be turned over to the defense team, regardless of what investigation the defense team is doing. They have to. That's the law. So, yeah, it's not Mark Means not doing his job. That's a different issue.
There's only so much the defense can do. All investigation and evidence and all that stuff happens on the prosecution side, and they have to give it to the defense. He can't just go out and take whatever. And that's probably what they're arguing over. He needs his own. They probably want their own testing lab to test whatever this is. But they have to get it from the prosecution. That's who has it. They can't go get it themselves.
Yep. Brenda Starr says, I didn't think that David and Melanie were ever married. They were. They were married on December 12th, which is the anniversary of Alex Cox's death. So, yes, and their marriage certificate is up in Discord if you want to go check it out.
And their bad wedding picture.
Yeah. Henriette Erasmus, thank you so much for the super chat. I really appreciate that. That really helps me to keep doing these kinds of videos and all the research. Here's a question from Diana Simmons. Awen, you might have already covered this, but regarding the DNA request, is it your feeling it's in regards to Tammy's death and so not pertinent? No. Yeah, you have to watch the replay. We talk about that. This has nothing to do with Tammy's death. It has nothing to do with Alex, Charles, Tammy, or Joseph. This is in regards to the children, and I believe it is forensic DNA, like skin cells or something left, a touch DNA, that kind of thing. So that's what this is about. Let's see.
The Patrick Frazee case, it was a piece of what they believed to be
A tooth?
Kelsey's tooth. It was just a piece, and they knew if they tested it, it would completely disintegrate.
Destroy it, yeah.
And they argued over that for a while.
Mm-hmm. Jenny Stern says, we just need to put Rachel Smith in charge already. I agree. I was surprised to see this interaction with the attorneys from Rob Wood now that Rachel Smith is here. So I'm a little curious about what's going on over there in the prosecutor's office. Maybe she's just relocating up here and hasn't jumped in with both feet yet. Hopefully she will, because I think the organization level will become much better, which is what we need. Sam Costa says, Rob Wood just informed prior and means that he does not have Tammy Daybell's autopsy results. He did. He did say that in his letter that the Fremont County prosecutor has not turned over Tammy Daybell's autopsy to Rob Wood. I'm calling shenanigans on that one, but whatever.
He might not have physically handed him a file, but I bet you he knows everything in it. I guarantee you he knows what's in it.
Mm-hmm. Yeah, but that is, like Heather and Oz says, why is Tammy's autopsy wanted? That case is not about her death. Or this case. And you're right, this case has nothing to do with Tammy Daybell's death at this point. So nobody should be talking about it or asking for it. But they are. Here we are.
Yep.
Let's see. Tracy Schiller says, but if P&M are demanding evidence that doesn't concern the case, then Wood can say, no, they're not demanding evidence that doesn't concern the case. The things that they did ask for, some of it was considered work product, and the judge went through it and said, you are not entitled to X, Y, and Z. But he told Rob Wood, you do have to turn over all these other things. So yeah, the judge is being very fair and very conscientious of what they're asking for, and Rob Wood has not complied entirely, so that's still a problem. I bet we're going to hear about that on Wednesday for sure.
So, like, if they had a stack of cell phones and they ran Cellbrite through it, they would be entitled to the raw data. They wouldn't be entitled to however many hours somebody or Rob Wood put into doing a timeline that pins this, that, and that person. I mean, that's what they're arguing about there. You get the raw data. You don't get what Rob Wood work-wise has put into organizing it or whatever.
Mm-hmm.
Yeah.
Let's see. How are DNA testing labs different? Isn't DNA testing straightforward? Why would they fight over who tests it? Well, Tara, like we saw in certain cases, let's talk about the Stephen Avery case, right? The woman who did the DNA testing, through all kinds of testimony on the stand, we find out that she didn't use the proper procedure. A lot of the samples she tested were contaminated. There's a lot of things like that can go wrong in DNA sample testing. Imagine if they have one sample, just one to test, and it gets contaminated, that evidence is lost forever.
Look at the staircase guy.
Mm-hmm.
Do you remember? Not only his case got overturned, but that the guy who worked for the lab, they overturned I don't know how many cases because of the way he tested stuff, threw it all out. Mm-hmm. The whole lab. I mean, not just one case. The entire lab was contaminated.
Mm-hmm.
That's a big deal. Yeah.
It is. Kat Stallsworth asks, so what do they do when there isn't enough DNA for more than one test? Generally, both sides, the state and the defense, will stipulate to a shared testing environment where a representative or an expert from both sides will be at an agreed upon testing lab. They'll be able to watch the procedure to check for procedural norms, things like that. And they will both have equal access to the test results. That's generally what they do. Both sides say, okay, there's only one test, so let's do it together. And that's probably what the judge will order in this case. That's what I anticipate saying. So Jeannie Piercy says, you are so wrong. You're not a DA. Okay. I never said I was a DA, but I'm not wrong. Anyway, let's move on. Let's see. Someone says Mark means let's divide the baby. What evidence do you have for that? That's not even. No. Goodness, guy, ask me some good questions. Let's not do the pitchfork and torches crap today. Okay, Rob Wood doesn't have the DNA samples the lab does. The DNA samples are either currently at a lab in safe storage or in law enforcement's facility. So they're not like sitting on his desk. No, that would not work.
No, I meant he would know about the things that are technically belong. That was my statement. That wasn't yours. So.
Oh, okay. Let's see. Maybe Rob Wood felt he had to talk about Tammy's autopsy in case the defense is playing silly buggers and wants to cast doubt on all the evidence the prosecution offers. Perhaps. Yeah, that could definitely be. The Zoom hearings are letting the attorneys become too familiar and disrespectful to the judge. Mark Means playing with his phone during hearings, for example. I don't agree with that because, if you watch a trial, have you ever watched a trial? If you watch the attorneys sitting at both tables, state and defense, a lot of them will be on their phones, especially if they're not part of the current conversation going on. The last couple of hearings we've seen were between John Pryor and the judge and Rob Wood. Mark Means, because of things that we know are happening in the case, was not actively arguing in those hearings. So yeah, he may have used his phone, but we see that in trials all the time. We see that right in front of a judge when they're sitting in a courtroom. So I don't think a Zoom hearing actually would impact that any differently. But as far as disrespectful to the judge, the only attorney I've seen that was disrespectful to I can't even say that, disrespectful to the judge was John Pryor several times now. Mm-hmm.
I always think of the Amber Geiger trial and Judge Mabel. What's her Kemp? Something like that. Do you remember when she took up somebody's laptop and somebody's cell phone? Like some third grade teacher. You can have it back after the trial. I still remember her saying that.
Yep. Beth Gaither says, but which side decides what test to order if you only have one sample? Traditionally, there's only one test that they need. They need mitochondrial DNA, right? If they're going to use, mitochondrial is the maternal one. I think I'm so confused now. The basic DNA test to show whose cells those were. Suppose they got a smudgy fingerprint off a garbage bag, for example, and they could get some epithelial cells, some skin cells off of that bag. All they want to test for is whose DNA was that. Get the DNA sample, get it done so that they can compare it with DNA from other people involved in the case and try to figure out who it is. So I don't think it's a case of where they would have to do lots of different testing. We get into tricky DNA testing, especially with hair samples. That gets really tricky, and that they might want different tests for. So, if it's a hair, yeah, that could definitely be a problem. So,
or if it's a mixture, that's when you get a problem. How many different people it belongs to, that kind of thing. You went completely silent, Ewan. You are muted. You're muted.
How did that happen? I'm sitting
there. You go.
Anything, and my mic just mutes itself.
There you
what
go.
Is that? I have to figure out what's going on there. But Jenny Stern asks, so what would you list the odds of new charges, murder or conspiracy, happening at the June 9th hearing as a way to honor the children? Absolutely not. The June 9th hearing is a status conference. It's not the place to bring new charges. You don't walk up to a judge and say, hi, we're here for a hearing, but look, I've got new charges. It's not how it works, unfortunately. Could he drop charges that day outside the hearing? Sure, if he's ready to. I don't see it happening, though, unfortunately.
But Rachel still hasn't been added to Lori's case either. So
correct.
I don't expect to see that till we see that hearing anyway.
Definitely. Yeah, there's a lot that's going to happen on June 9th. We'll probably have the motion for severance from John Pryor, the motion to dismiss, the motion to change venue, perhaps the pro hac vice for Lori's case. So June 9th should be a big, busy hearing unless they take care of some of that before that date. But it should not be new charges on that date. So, unfortunately.
If they split these, man alive, it's going to be double the amount of this hearing.
Yep.
Discovery back and forth.
Judy McGuire asks, so when do you think this is going to go to trial? Jess, what do you think?
4 years.
I'm
not even kidding. I think it'll be that long.
I would say 2023. Well, maybe the end of 2023 at the earliest. So, although the current charges, they could bring this to trial the end of this year. It's now tentatively scheduled for the fall of this year. They moved it. These are not the biggest charges in the world. I think they could probably be ready to bring these to trial this year if they stop there. Let's just do these charges and get this done and out of the way. Is that going to happen? It doesn't seem so. From all the things that we've seen the last couple of months, it does look like Rob Wood is putting things off to be like, wait, I'm going to bring the whole thing at once. So let's just hold off on stuff. I don't know. We're going to have to wait and see. But my feeling is we're not going to see anything as far as a court of law till 2023 at least. But
plus, if they do separate the cases, and if they do get a change of venue, all of that goes on a whole nother system's calendar. So they will lose where they're at now. Resetting it. They move it.
Yep. Kat Stallsworth asks, do you have any theories on why they're asking for Tammy Daybell's autopsy report? Well, of course they'd want to know what that is. As a defense attorney, especially Chad's defense attorney, he would want to know what that autopsy result says because he's got to know what's coming down the road for his client, But they're just asking to ask, I think, at this point. Once charges come, then obviously they will get those autopsy reports if charges come. We don't know what the report says yet, so there may not be murder charges coming for Tammy. So that's another wait and see, unfortunately. Brenda Starr asks, wouldn't all of the samples be at the FBI lab? And I will say no to that just based on Rob Wood's own letter that we just read. He says it's someone with law enforcement or this and that, so they could be all over the place. We don't know, unfortunately. Oh, let's find another question, Jess. What do we got here? Yeah, Rosie's saying she can't hear me. See, that's how far back I am in chat. Does anyone know if Gib and David were married in an LDS temple? You want to take that? No, they were not. Yep.
They were married in front of a dirty blackboard, from what I remember of the picture, right?
Well, the picture that I saw, they have like a religious iconography sort of picture behind them. And apparently it was in like the rec room of a church or something like that. Yeah. So, yeah, it wasn't a formal big church temple-y ceiling kind of wedding. So Diana says, so it could be DNA for identification. Proving it's definitely Tylee, not a raccoon. Whoa. Wait, who's calling me?
You muted yourself again. Just saying. You're muted again.
My goodness. Why does that keep happening? We already know for sure that the children have been identified as Tylee and JJ. That's already known. So this DNA that they're talking about is not the kids' direct DNA because they don't need to fuss over how much samples they have because they have their entire remains, so they can go get more DNA if they need it. So this is about some sort of forensic type DNA.
Plus, we know from the prelim they didn't find a raccoon.
That is true. All right, so Miss Wheelassie, at one point would the judge step in and chastise both sides for making petty requests constantly? I don't think he'd ever do that because these aren't petty requests. They're not. But he may say, I gave you an order. You should have complied with it. And because you didn't, now we've got these 14 other filings from the defense because you won't complete. He may chastise them that way, but he won't. He would not chastise a lawyer for making a motion that is based in law. Yeah. Right? Does that make sense?
You don't see very many judges really getting on to lawyers. You kind of really have to push them.
Yep.
To see that. Mm-hmm. In my experience, I mean, I don't know. Maybe it happens a lot, but I don't know about it.
Tracy Scheller asks, what do you think of the severance? I'm surprised it hasn't happened yet. Back when we had the motion for joinder, although I was very much in favor of the joinder because it does save the state a ton of resources and it saves the family having to go through these trials more than once. So I'm very in favor of the joinder. However, I also said I expect to see a motion for severance like within a week, and it's been months. So I'm surprised we haven't seen it yet. I'm convinced it is coming. It probably will be for June 9. So
I'm surprised it didn't happen when they added Rachel to Chad's case and not Lori's. That would have been an obvious waypoint, you know?
Yep.
They didn't. We'll see.
Tara Well says, wow, 4 years? This is no CSI episode. Yeah, it's definitely not. This is the reality of these kinds of cases. Sadly.
Tim Jones Jr. took 4.5 years to go to trial, and he confessed.
Mm-hmm. Yeah, that's true. We don't even have a
He took them to the
confession.
bodies, and he confessed, and it took 4.5 years.
Mm-hmm. Lisa Irwin asks, could it be DNA from the duct tape? It could be. We have no idea. It could be on something in Chad's house. It could be on a car door somewhere. We have no idea what this DNA evidence is, and we're probably not going to find out until it goes to trial, but it's something like that. Something. I've got to catch up with chat. I am so far behind. I think this has to do with the duct tape and bags and buckets. Quite possibly, yeah. Sorry, I just answered that with another question.
If there's a murder weapon, or we don't know what they've got. I have no clue.
Yeah, T. Cole asked another question. I'm going to address this just because I am in a feisty mood tonight. T. Cole says, do you mean Rob Wood didn't turn over his grandmother's tweets? No, T. Cole. I mean, Rob Wood didn't turn over discovery that he was ordered by the court to turn over. How's that? You want to keep coming at me with this ridiculous conversation? Because I've got better things to do. So please stop. Just stop. I'm not in the mood for that. Miss Irvina asks, I wonder if over time they might get enough money together to bail out one or the other. What do you think, Jess? That would scare me.
How? They going to take up a church offering? What are they going to do? A bake sale? No. Well, I mean, start selling off Lori Vallow's hair as it falls out.
What if the families got together and tried to maybe have bake sales or to raise money?
If their family isn't smart enough to leave those two murderers behind bars, they deserve to get whatever happens when they get out. They can't even talk to anybody when they get out. Mm-hmm. Where would they go? Where would they go?
They would be in danger.
Took Daybell's house.
Yeah, if they were released, they'd be in physical danger. They would not be able to talk to anyone. I mean, they are better off where they are, even from their point of view right now, which I'm sure they don't agree with. But, from a logical point of view, they need to stay right where they are.
Can you see it? Lori Vallow gets out and she just goes and moves back in with Colby. Can you imagine?
No. Let's not let that happen. Oof. And Got Case says, Missy, I doubt it. I don't think any bondsman will touch them. There was a point where there was a report, oh, goodness, last fall, I think, of Lori possibly bonding out. And I even called the bond company myself to verify, and they said, no, it's not happening. So, good. There you go. Let's hope they stick with that. Hopefully. Let's see. Chelsea Diaz, hi, how are you doing? Says, even in a bond situation, you have to have assets to cover the bond, and Chad has already turned over his home to private. That's correct. You need 10% cash up front, so they need $100,000 each, plus more for Lori, because she has the additional charges. Plus, they have to have a surety for the remainder of the bond. You can't just say, well, here's $100,000 on $1 million bond. Is that good? No, you have to have some sort of assets to prove as collateral for the remainder of the bond, and they don't have it. They don't.
Everybody that had money around Lori is dead. Mm-hmm. Everybody who paid Lori's bills is gone. So.
Yep. Tara Wells, what would cause Miss Smith to not be added to Lori's case when she is on Chad's? There's a very specific reason for that. I'll give you the general breakdown. Is that in the March 8th hearing, there was an agreement made between all the parties and the judge, and right now things are not being heard for Lori's case specifically, and that'll be resolved soon. So that's all I can say about that right now, but it'll happen. So deep breath. Kresha is here. Yay.
Hi, Kresha.
She said they both need an old priest and a young priest. Yep. You know it. Oh, goodness. Please put some purple and blue hearts in chat for Kresha. If you don't know, Kresha is JJ's aunt and the niece of Charles Vallow. So we're so glad she's here. Please show her some love in chat. Cynthia Berg says, Tara's question is a great question. Did I miss it, or is that the same question? No, that was the question. Yeah, that was a good one. Kat says, maybe John Pryor didn't push to sever because at the hearing where Ms. Smith was appointed, he thought he was going to be able to block her from joining. Possibly, although at the time when the motion for joinder was created, I doubt John Pryor knew that Rachel Smith would eventually be added to the case. So, maybe he was just waiting, but I'm pretty sure. I was surprised we didn't get that filing this week, so I anticipate it for next week. I do know that there are more filings and things coming next week. So next week should be an interesting week. So don't forget to stay tuned for that.
I doubt that Pryor really thought he could keep her off of Daybell's case. Do you? I mean, I think you argue it just to argue it, but I don't think he really expected that he could block her. It's kind of like halfway through the trial when they ask for a mistrial over something, or all the charges to be dropped before the defense takes over their side of the thing. They argue it, but I don't think they ever think they're going to win that argument.
Yep, I agree. Salty asks if she can get a glimpse of my nails. All right, let me look at StreamYard so I can see if it comes in not blurry. These are my current nails.
Oh my goodness.
They're very long and very curvy and very in the way. So if I don't answer your texts and stuff, this is why. I can't type with these on. Be crazy. So yeah, those are my Lisa Discovers asks, what do you think the holdup is with Lori's case? I just covered that from another question, so I won't go over that again. Kresha says, my stepdad, Dennis Trahan, who is my brother Todd's dad, passed away today. Oh no. It just doesn't stop rolling in, y'all. Prayers are so helpful. Thank you for those. Oh, Kresha, I'm so sorry. Oh, we had such a fun talk yesterday, and now for something that sad to happen. I'm sorry. If you ever need to talk, just call me. I don't care if it's 3:00 in the morning. All right. I'm always here for you. I'm so sorry to hear that. Please extend my condolences to your entire family. And man, y'all didn't need that. I'm sorry, honey. Oh, so please let's get some prayers and love up in chat for Kresha. Oh, that's bad news.
Yes.
Yeah. Yep. It does get worse, Judy McGuire. It really does. Yeah. Oh, that's sad. So, another thing that I wanted to talk about briefly tonight, I'm doing a ridiculous amount of research on this case. Oh, Joe P.A., thank you for the super chat. Joe says, when it's all said and done and they are sentenced, do these two ever get out of prison? On the current charges, yes, they will get out of prison. If we get murder charges or something like that, no, they won't. No, they won't. So we're just going to have to wait and see. Yeah, my research project. Right, I'm doing a lot of research. I actually have a team of people that are working with me on various aspects of research for the case. A lot of things have been missed, I think, in evidence, and we're going through everything with a super fine-tooth comb. If you'd like to take part in it, let me know. It's a lot of work. All right, you have to be very computer savvy. You need to understand how to use Discord and Twitter and Reddit and Facebook and all these things. And we're doing familial searches through Ancestry and all kinds of other stuff. And why is my YouTube making faces at me? Come on, YouTube. So yeah, it's a really big issue. All right. So if you want help, if you want to help, just let me know. We need all hands on deck because it's that big of a project. But it's going really well. So that's why I've been a little bit quiet, not making too many videos, because I am in the weeds as it speaks. Big in the weeds. Jess, are you in the weeds? You want to come in the weeds with me? It's fun.
We're in two different patches of weeds, but we're in the weeds together.
Yep. I'll wave at you from my weeds. You wave from over there.
Yeah.
Jenny, any plans to write a book with all that research? No, not me. If I'm writing a book, it will be my Toxic Bliss series. I'd like to have that as a book someday. For this, I just want to see T. Cole. Really, that's obnoxious. Get out of here, dude. Boom.
Don't waste your time.
Yeah, really. If I write a book, it's going to be about Toxic Bliss. This case, I know someone who is writing a book about this case, and she will have all of my research at some point. Wonderful Miss Lori Hellis. So yeah, that's happening. So that's what we have for you about all of these new filings. All right, I do expect more next week. I have been told to expect more stuff next week. So I'll be watching. Wednesday, don't forget, Wednesday morning, we're going to go live with that hearing. Whether it's in a breakout room or not, we're still going to be live. We'll talk about it. We'll see what happens. Last hearing, I didn't expect to be public, and it was. So awesome. We'll do that again this week coming up. So stay tuned for that. Please hit the notification bell. That way, if the time changes on the court hearing, you won't miss it. You'll still get a notification from YouTube on that. Jess, what else do you have going on in your end of the world?
April is Child Abuse Prevention Month. So I've got a couple of videos going right now that kind of went down a rabbit hole and stalled me a little bit. But I can ask if anybody's interested. I'm going to be doing a video on a 15-year-old that's in Washington who was autistic and nonverbal, who died after CPS was involved. And that kind of led me down the trail of, that happens a lot. We keep seeing cases of kids that are dying after CPS has been involved, and I think it's a problem. So I'm kind of working on a video. If you guys want to know of a case where it's already been through the court system and the kids died after CPS was involved, send me some names. Because that tends to come out in local news. That doesn't normally make big national news.
Definitely.
But I'm working on maybe getting some accountability from CPS out of different states.
Mm-hmm. Good. I'm 100% behind you on that, and will help any way I can. Beth Gaither, a $5 super chat. Thank you so much. Just thank you for all your hard work. You're welcome, and I cannot put a price on trying to get justice for these two babies. I can't, and I am so excited to be able to help in any way I can. Susie Heath, thank you for the super chat as well. I really appreciate the support. It helps so much, especially the amount of money I've spent in background searches lately. Goodness.
No kidding.
I know. Someone asked a question in chat. I'm going to hit on this just for a second, and I'm going to maybe try and limit it to 2 sentences. I went in quite a rant last night on my Patreon video. I don't want to hear about psychics. I don't want to hear about satanic death calendars. I don't want to hear about crazy birth date and doctrines and covenants, scripture combinations crap. I don't want to hear that crap. I don't. I am too busy looking at names, dates, times, airline records, real facts in this case, and putting together real verifiable information. I don't have time for that nonsense. All right. So that's not what I do here on my channel. More power to everybody that does. I think that's great. There's certainly a calling for it. People love that kind of stuff, but that's not what this is about here. So yeah, let's not do that here.
If you got it documented, like that it happened, maybe, but this case is horrendous enough without adding all of that to it. I'm not even gonna say what all of that is, but that doesn't help. It doesn't help.
Yeah, definitely. Ginger Artist says, I know it's the Daybell case. I just didn't think there was another hearing until June. Right. There was not supposed to be, but the defense has requested an emergency hearing with the judge to argue about the DNA evidence in the case. They want to make sure that the testing that Rob Wood wants to do will not consume all available samples of the DNA, which would prohibit the defense's right to test them with their own experts. So there should be a hearing coming up on the 8th, 28th at 9 a.m. Mountain Time.
This won't be the only hearing between now and June.
Right.
Guarantee it.
Yeah.
They'll probably add Rachel to Lori's case. They'll probably argue the venue change and all that. We'll see something out. They'll still be squabbling over discovery. The pattern holds. You never know.
First, Lisa Discovers, thank you so much for the super chat. I really, really appreciate that. Definitely. Kresha has something very interesting. She says, her and JJ's birthdays and Tammy's are in May, and she wants to raise awareness on mental health, which ultimately blankets all facets of these tragedies. I want to call it May Day, a call for mental health. Kresha, let's do it. Let me know how you want to set that up. I am 100% a May Day movement to bring mental health awareness to these situations. Goodness knows, true crime, all the stuff that we talk about, we are always ending up talking about psychology and mental health and where to get help. So 100% behind that. Let me know what you want. I am all yours for that project. 100%.
May Day is what? May 1st?
Yep. But the May Day project, I love it. What a great name for it. May Day, calling out for help, but also celebrating May. And yeah, I like that. All the birthdays in May. Oh, that's perfect. That's great. I love that. Shelly Tarbert, it's good to see you again too. I'm glad you're here.
I'm gonna be sitting out May Day in May too.
Yep. Kresha,
Yeah,
I'm going to
Noah
send
turned
you.
16 May 25th. Everybody better watch out for that kid getting a license.
Yeah, I'm going to, Kresha, I'll send you a text and stuff. I'll get you more in touch with Jess, and we can definitely put some heads together. Let's make it a big thing. I want that to be National May Day.
Yep.
Let's do
Sounds
it.
good.
I'm doing it. All right, so there's a lot going on. If you want to dive in to the research projects, it's dry. It's not fun.
You muted again.
What is going on with my microphone? I don't know why it keeps doing
It
that.
doesn't like you.
My goodness. Could be the wires loose, probably a new one.
I
But
think you said something about the psychics, and there you go.
there you go. They broke my microphone.
That's what it is.
Chad, get out of your portal. Leave my microphone alone. So if you want to dive into the research project, let me know. It is dry and boring. It's not fun and scintillating and any of that. No, this is hard work and a lot of it. But we need all the hands we can get. So just let me know. Reach out on Discord, email. Discord is really the place to be for all of the stuff that we're doing. So please join the Discord. It's totally free. It doesn't cost you anything to join. And we'll get it going. And I will get with Kresha on this May Day plan. And I am 100% committed to making that happen with her, anything she needs. So excellent. Yep. So, Jess, we got a lot of stuff going on. We are busy people.
Yeah. A lot going on behind the scenes. A lot.
Yep. And how is your husband? Just for everyone to know, Jess's husband was recently in the hospital, and we are pulling for him too. So please send some positive thoughts his way. Is he feeling any better?
He's on enough medication that he doesn't know how he feels. So we're
there
good.
You go. That's all right.
He sleeps. But yeah, he got out of the hospital yesterday, so it was a week. But
yep. Judy McGuire.
So it was okay.
Judy McGuire asked if we spent the day at the spa because we look beautiful. No, but we do have our antlers on. I think that's what it is. Yeah. We're wearing antlers. We've created a line of merch called the Antlers Amicus because we are just so in love with Mark Mean's antlers on the wall, and is the funniest thing I've ever seen. So we wear our antlers to be funny. It helps bring a little brevity to this case of just horror. But that's what the antlers are all about. So if you check out my Teespring, get an Antlers Amicus t-shirt and join the group. So, Kresha has something. She said this to me yesterday, and it is so true. So take a second and digest this. We have to get comfortable discussing things that are uncomfortable. We really, really do. And that's what a lot of this case is going to be about. It's a quote from Corey Gauthier's. I don't know how to say that name. Corey Gautier, whatever. Corey Gauthier's Uncle Spencer. So beautifully spoken. It is so true. We're going to have a lot of uncomfortable things to talk about as this case goes forward. But the more we can talk about them, especially like mental health awareness, the more we can confront it head on and not be embarrassed and ashamed, the better we can deal with it. So absolutely. That is a big, big thing for us to do. Lisa's covers love the antlers. Yeah. Jess sent me the ones with the red sparkles, and she has the white sparkles, and I love them. Thank you, Jess. I love my antlers. All right. So I think that's all that's going on. I'm not going to do another live over the weekend because there won't be any more filings now till next week. So that's all that's going on right now. Stay tuned for Wednesday morning. We'll bring you the hearing. Probably hear from me Monday or Tuesday with some new filings that I anticipate. And that's that. If you want to jump into our weeds, because we are in the weeds, reach me through email, Discord, Facebook, Twitter, whatever. Find a thing and find me. We'll do it.
She's out there.
We're out there. The truth is out there too. Well, let's find it. So, anything else you want to talk about tonight, Jess, before we go?
Did you want to talk about Mark Means on Court TV and what colors he should have chosen?
I do want to talk about that.
Dude, don't wear brown. Don't wear brown.
It was gray. He had a gray champion
don't wear
sweater.
Neutrals. Don't wear neutral. It washes you out, dude.
Yeah, Mark, if you're watching this, we recommend jewel-toned sweaters if you have to go the sweater route. Although you might want to consider a shirt and tie and then the sweater. I know you want to seem approachable and friendly, but the suit and tie really, shirt and tie lawyer stuff. But put a sweater over it. But I would suggest jewel-tone, dark burgundy, navy blue, hunter green, Ralph Lauren, get the little horse thing. That'd be better than a gray champion because it just looked too washed out in those lights.
If we're going to hand out advice, John Pryor, if you're watching this, smile. It won't kill you.
It might.
Just smile.
I'm afraid it might.
I'm going to leave
possible.
that word. Just smile.
Yeah, sweater, shirt, and tie is what. Yeah, feeding it. I agree with that. Sweater, shirt, and tie would be great. Sam says, thanks to all the mods for a job well done. By the way, Means introduced himself as a criminal defense attorney. Well, he is a criminal defense attorney now. He is, so I guess that's okay. But yes, thank you to the mods. To Sake Wood Second, Rosie, Feeding It, everyone that's here, Mimi, all of you guys. I could not do this without you. You guys, my mods, they don't just sit here and watch chat. These are my team that are doing all the digging and research and all this stuff and running the Discord servers. They are super, super busy. So a huge thank you to the mods. Absolutely could not do that without any of them, including Jess, who's also a mod, but she's not really a mod. She's more my partner. So, yeah.
I shop on Amazon. Like, this is important.
Mm-hmm. Yeah. Oh, Danielle, she just joined Reese's Pieces. Yay, welcome, Danielle. Reese's Pieces. We should get like bags of Reese's Pieces to mail to people that join.
No, we don't, because we will eat them.
I like them. Of course I'll eat them.
We would eat them.
Fine. Crash says, John Pryor's, her advice to John Pryor is to get a script for blood pressure meds. I'd agree with you on that. Yeah.
I have some advice, but I don't think it's nice. So I'll
probably not. Let's save that for Patreon videos. We get in trouble. Oh, goodness. All right. So we're done here for this evening. All of these documents are available in Discord if you want to read them through yourself. They'll always be there. And we're around. If you want to talk, if you want to jump in and play with us, let us know. We're here for you. And we'll see you guys at the latest next Wednesday morning. So bye for now, guys. Thank you for being here. Let me find the goodbye button. There it is.
Next to your mute button.
I know, right?